When a loved one dies, grief is often followed by another harsh reality, the absence of a will. For many of you, that moment opens the door to legal uncertainty, disputes, and long waits before you can access what your deceased relative intended to bequeath. Attorney at law Christopher Henry says when someone dies without a will, the law determines who has the authority to manage the estate.
The legal authority vests in the person who would be designated as the administrator. This comes from the Estates, Intestates and Property Charges Act, and this is an application for a grant of administration that has to be sought from the courts, and that application is to be made by either the spouse or children. And then there's another list of priority that goes from after the spouse and children, if there are none, brothers and sisters, parents, grandparents.
Many people assume that when a husband or wife dies, the surviving spouse automatically receives everything. But according to Attorney Henry, that is not always the case. Under Jamaican law, assets are divided according to a legal distribution formula.
So it is spouse, children, brothers and sisters, then they separate brothers and sisters from brothers of the whole blood and brothers and sisters of the whole blood and brothers and sisters of the half blood. Then they go to parents, then they go to grandparents. For some reason, nieces and nephews are not included, neither are grandchildren. The table of distribution also speaks to that the spouse is not to get all. She is to get all if there is no children. If there is children and if it's only one, they split it 50-50.
And when the deceased owned land, a house or other property, the situation can become even more complex. Before any property can be sold, transferred or legally claimed, you must first go through the proper legal process, often requiring the court to appoint someone to administer the estate.
You have to make an application for a grant of administration. This is made at the Supreme Court. Before you even reach to the Supreme Court, and because the person died without a will, you have to seek the certificate of the Administrator General so that it can proceed to the Supreme Court to make the grant of application. Note as well that in the event that the estate contains or has minor children, the Administrator General's Department is mandated by law to administer that estate. So they can issue their own instrument to administer that estate if there are minor children.
These situations have led to family disputes, delays, and expensive legal battles.
Deadlift is one of the most contentious things in this world. If it is not fighting over land, it is fighting over money. And in fighting over those things, much of the issues could have been solved if the person had just simply written their will. Because it would have stated who is to get what and who is to benefit from the estate from who is not to benefit from the estate. So I would encourage everyone watching this, please, you're not going to die tomorrow, make your will. If you don't want your children, no screechy and go to your lawyer and just make your will, please.
The easiest way to avoid these complications, prepare a will before you die, because without one, the courts and not your family will ultimately decide who manages the estate and how assets are shared, a reality many families only discover after a loved one has already passed. That's all the time we have inside Query This tonight. Remember, if you have a legal dilemma or concern you would like us to query, send an email at aorrett@cvmtv.com. I am Akeem Orrett. See you next week on Query This.